No one expected the courtroom to fall silent so quickly. Supreme Court Justice Amy Coney Barrett, known for her sharp intellect and strict constitutional lens, looked directly at Elon Musk as she addressed him from the bench. "Mr. Musk," she said, voice steady but firm, "your actions demonstrate a pattern of disregard for established legal precedent." Musk, dressed in a simple dark suit and blue tie, didn't flinch. The billionaire tech mogul stood behind the respondent's table, refusing to let his legal team speak for him. In front of him sat a closed folder. "I understand the concern, Justice Barrett," he replied calmly, "but I don't believe that's an accurate characterization." Barrett's eyes narrowed. "Your company, X Corp, has ignored federal requests to comply with content regulations under the revised 2023 Communications Act. Are you claiming exemption from the same rules every other platform follows?" "With respect, no," Musk replied. "We've never claimed to be exempt. What we've done is challenge the constitutionality of those directives." Barrett flipped through her notes. The record shows 17 formal notices of noncompliance. 16, Musk corrected politely. "And we responded to each one with legal rationale based on precedent." Gasps spread across the room. It was rare, borderline unthinkable, for someone to interrupt a Supreme Court justice, but Musk remained composed. Barrett, clearly annoyed, didn't back down. "This court has little patience for technical corrections," she said. "What's at issue here is a consistent refusal to comply with federal law." Musk opened the folder. "What's truly at issue," he said, "is whether a government agency can use regulation to compel speech control, something this court already ruled against." Barrett froze. Her tone shifted slightly. "Are you referring to NetChoice v. Paxton?" "Yes," Musk replied. "In that decision, you wrote that the government cannot use regulatory frameworks to pressure private platforms into enforcing speech policies on its behalf." Now the courtroom leaned in. Justice Thomas and Justice Kagan exchanged glances. Barrett sat back, still composed but clearly surprised Musk had studied her opinions so closely. "I believe," Musk said, "that the FCC's directives are an attempt to achieve indirectly what the Constitution prohibits directly." Justice Barrett's gaze remained steady as she examined the documents handed to the clerk. The air in the courtroom was tense, anticipation coiled like a spring. As Barrett flipped to the highlighted section, Musk's voice broke the silence. "These are internal FCC communications, obtained through FOIA requests." Page 47, Justice Barrett. Commissioner Thompson writes, and I quote, "While Barrett's opinion restricts our direct authority over content moderation, the technical compliance regulations give us an alternative pathway to achieve the same outcome." Gasps rippled through the chamber. Barrett looked up sharply, her eyes narrowing slightly. Around her, other justices were reading the same page, expressions shifting from curiosity to concern. Justice Alito adjusted his glasses. Justice Kagan leaned in. The courtroom was no longer watching a reprimand. It was witnessing a shift. "Mr. Solicitor General," Barrett said, her voice cool, "do you wish to address these documents?" The government's attorney stood, visibly tense. "Your Honors, these communications lack context. They were not submitted in the lower court proceedings. Because the FCC sealed them," Musk interjected, calm and precise. "We obtained them just 3 weeks ago, through a successful FOIA lawsuit in the Ninth Circuit." Justice Thomas leaned forward. "Are you suggesting these documents were deliberately concealed from judicial review?" "The evidence speaks for itself, Justice Thomas," Musk replied. "They show a clear intent to sidestep this court's precedent by using technical regulations as cover." Barrett's tone hardened. "Mr. Musk, your claim is that the FCC knowingly attempted to achieve, through regulation, what the First Amendment prohibits the government from doing directly?" "Yes, Your Honor. That's exactly what happened." Barrett took a long pause. The courtroom was utterly still. "You're referencing NetChoice v. Paxton, where this court held that regulatory pressure cannot be used to indirectly control protected speech. And Youngstown v. Sawyer," Musk added, "which allows parties to seek judicial relief before complying with unconstitutional directives. We filed for emergency stays in 3 circuits. All were denied, narrowly. Barrett nodded slowly. I'm aware of the dissents, including one written by Justice Jackson. From the bench, Justice Jackson offered no response, though her gaze lingered on Musk with renewed interest. The Solicitor General tried once more to reframe the narrative. Your Honors, Mr. Musk is not a lawyer. His interpretation of this court's rulings is fundamentally flawed. But Barrett was no longer skeptical. She glanced again at the document in her hands. Counselor, the constitutional validity of these directives is precisely what appears to be at issue. She turned to Musk, her voice quieter now, but more focused. Please continue with your argument, Mr. Musk. The courtroom, once tense with anticipation, had shifted into something entirely different. Elon Musk stood confidently, no longer just a tech CEO defending his company, but a man delivering a constitutional challenge few had expected. Justice Barrett, he said calmly, your opinion in NetChoice v. Paxton made one thing clear. The government cannot use regulatory pressure to control speech indirectly. That principle guided every step we took. He pointed to the FCC memos. These documents show officials openly discussing how to use technical compliance as a workaround to enforce content moderation without calling it that. Justice Barrett read through one of the highlighted passages. Around her, justices exchanged looks. Justice Alito was the first to speak. If these communications are legitimate, this could represent a serious constitutional violation. The Solicitor General attempted to push back. Your Honors, these are isolated excerpts. They're not, Musk interrupted. There's a clear pattern. The FCC knew it couldn't mandate moderation directly, so it tried to coerce it indirectly. Barrett's tone shifted. Mr. Musk, your position is that you weren't defying lawful regulation, but resisting unconstitutional overreach? Exactly, Your Honor. We filed for emergency relief in 3 circuits and documented every objection. We weren't just being rebellious, we were defending First Amendment rights. 3 days later, in a rare move, the Supreme Court issued an administrative stay, halting all FCC enforcement related to the challenge directives. The public reaction was immediate. Legal commentators called it a historic moment. Clips of the hearing spread online. Musk, once the expected villain of the case, was now seen by many as a surprising defender of constitutional limits. When asked at a press event how he managed to hold his ground, Musk simply said, I'm not a lawyer. But when the Constitution's at stake, you do your homework.